I'm the president of the IIEDE, International Institute for Studies of State Law. Thank you for your presence this morning. This seminar, New Paradigms for Compliance in Brazil, a partnership of the International Studies Institute and the National Economic Development Bank, BNDES. We have the support of many institutions, especially Banco do Brasil, federal government of Brazil, Association of the Members of the Account Courts of Brazil, Law School of the Federal University of Rio Grande do Sul, Foundation Superior School of the Prosecution Office of Rio Grande do Sul, Advocacy Defense Movement, Getúlio Vargas Foundation, FCG, National Association of Federal Police Marshals, our office, Medina Osório Advogados, and other institutions that supported us, like the Superior School of the Prosecution Office of the Union, of General Attorney's Office, Justice Court of Rio Grande do Sul, to whom we thank deeply. Petrobras also publicized the event. Without these institutions, certainly the event wouldn't have reached the success that it did. I'd like to invite for this panel, this opening panel, Dr. Vanessa Reis, who is Director of Institutional Relations of IIEDE. To join us, I'd like to invite the legal regional manager from Banco do Brasil, Marcos Antônio Cordeiro Ribas, who will be with us also in this opening session, to who I'd like to initially give the floor to, so he can make his initial considerations about the relevance of this seminar. Dr. Marcos Antônio Cordeiro Ribas, you have the floor. Good morning, everyone. Once again, good morning, everyone. First of all, I greet panel's president of the panel, Dr. Fábio, president of the Institute, IIEDE, also our National Bar Association, the Brazilian National Bar Association, and everyone here with us. Our speakers at the event will have this morning. We try to approach the theme of compliance, which is our daily work. So it's a pleasure and an honor to participate in this event. I want to thank you thank the Institute for the invitation to the bank and providing the possibility for us to participate and sponsor the event, this compliance seminar, everyone, where we will approach the new paradigms of compliance in Brazil. This event, we will have authorities from many sectors, many organizations here with us. It's extremely important for us to be able to go deeper together into the evolution of the standards for compliance in Brazil. As mentioned here, we represent also Banco do Brasil, and with this, my pleasure and my honor to be here are increased. And I'd like to acknowledge, the presence of colleagues from the bank connected to the auditing sector and our direct our compliance sector, internal control sector on behalf of colleague Ivanaldo, General Manager of our audit in the state of Rio de Janeiro. We have some colleagues here by YouTube, also from our compliance and internal control sector, represented by our colleague Italo, who is joining us by YouTube. I hope he can hear us. And I also greet the presence of these colleagues that represent with the legal sector, these two sectors, audit and decoy, internal control sector and audit. We reinforce the defense and application of the compliance controls and handling the risks to which Banco do Brasil is exposed or susceptible. What's compliance? Compliance is in our daily lives, our personal and professional lives, and mainly here we will deal with regards to our organizations. What is to be in compliance? To be in compliance, we'll have the speakers. I'll just bring you a brief notion. Means be in conformity with the rules, the norms, the regulations. And for Banco do Brasil and the financial institutions, what's the relevance of compliance? So to be in conformity with these rules, these norms, these regulations minimizes pretty much or even may avoid the risks to which the banks, the financial institutions are exposed. We are in a scenario where we are susceptible to many risks. Banks, financial institutions, our organizations, us people are exposed in our daily lives to these risks, be in a scenario of economic crisis, financial crisis, innovations, right? In its many ways, internal and external risks to which our organizations are exposed. And compliance, which means verify if we are in conformity with these regulations, is extremely important so these risks can be mitigated. They are inherent, of course, to our activities, and the compliance that's efficient, strong, and robust is very important for the sustainability of our businesses. What does society expect from the banks and the financial systems? So, in a general way, they expect trust. Trust and compliance go hand in hand. Not that Banco do Brasil and the financial institutions have this trust assured, but compliance applied with care has to be foreseen in our governance policy, and in Banco do Brasil it's not different. We have this in our daily lives, our daily work. Banco do Brasil, for the ones who don't know, is the first company formally created in Brazil, the first financial institution of the country, and nowadays it becomes the largest financial institution in Brazil. We are an institution that is highly regulated, be internally or externally. In the bank, we have norms for almost all our activities. That doesn't mean it's an excess of bureaucracy. It's extremely important to have this compliance. The banks, and for having this public has regulation and controls from many institutions, like, for example, National Monetary Council, Central Bank, General Attorney, Accounts Court, the Union Controller's Office, and other entities. So internationally speaking, there are also regulations the bank must follow. be in conformity with, like, for example, the committee that oversees the Basilea Agreement and other entities as such. So everyone, so we have an application of these norms that is effective. We need a governance policy where compliance and internal control should be included, and these should be highly efficient. So this way the banks will fulfill to Brazil, financial institutions of the country, our organizations. So as I mentioned, this way we'll have sustainability in our businesses. The bank, which is a bicentennial institution, institution, it will surely, and I do hope so, has will last for other hundreds of years or other centuries. So if the bank is not in conformity, apart from losing the trust from society, what can this mean as an impact? Can impact the financial market, stock exchange, our economy as a whole, our businesses with our clients, our shareholders, employees, and the society as a whole. So compliance and control must walk together. They all must always be aligned. Control and compliance is a way of seeking for conformity. In the bank, we have daily, and specifically these three fields I mentioned, the legal sector, internal control sector, and our audit sector, this daily view and keeping attention to the risks we are exposed to. There are risks of many natures. There are financial risks, legal risks, economic risks, image risk, regulation risks. So we have to be in conformity with all the regulations, internal and external, to minimize those risks. The audit, GCOI, and the legal sector are part of these lines of defense in our internal control programs. In the bank, we usually deal with this matter since the beginning of our work, since our colleagues, the workers or the employees come into their careers and up to all levels. We have many internal courses where the relevant these lines of defense are highlighted. Can be keen to the control of all these legal sector, especially following the businesses of the many fields the bank has, because everything is departmentalized. So these three institutions, internal institutions or sectors, have the control and follow-up of the businesses effectively done. The bank, especially the legal advice, follows the business's structure with of regulation of legal risk. We have to be in accordance to our legal framework as a whole. So we have to measure risk and pulling it to our side, us lawyers, when talks to a client in his office, approaches risks. Even when considering legal strategy and lawsuits, he always measures risks. He always tries attention to these controls, and in our institutions are not different. Our risk, and with this way, reduce the risks. That event is very important for all of us who are here, for our society. That will be our final goal, but initially for our organizations. So our discussion, the discussion we'll have during this morning here, will be extremely rich, so we can analyze critically the performance of the compliance practices. We can also, during this morning, analyze the need for implementation, for effective implementation of robust programs that should be efficient for compliance and internal controls also. So this way we'll be able to strengthen the integrity, corporate integrity mechanisms, and legal conformity for our organizations. The bank also seeks here to bring our knowledge, will share information with our speakers. Evidently, we also seek to straighten our bonds with the Institute, with the Bar Association, with BNDES, with the organizations which are here. I always repeat this and on behalf of our society as a whole. So, President, Dr. Vanessa, I wish everyone an excellent event, excellent seminar. Thank you. Thank you.
Quero agradecer ao gerente jurídico regional, Dr. Marcos Antônio Cordeiro Ribas.
I just thanked the legal advisor from Banco do Brazil and also for the institutional support from Banco do Brazil. I'd like to acknowledge also the presence of the illustrious speakers who are here already at the event, but not before acknowledging also the presence of authorities in this event. Judge from the 13th Court, Dr. Luciana Lozado, Dr. Edson Teles, advisor from Petrobras in the presidency, and within other numberless authorities here with us. I'd like to highlight the illustrious speakers who are here. Dr. Patricia Miguel Gouveia, who will do the conference of non-rural. I'd like to call her to the panel. It's an honor to us. Presence of Dr. Marcos Vinicius Spinelli, who will do his conference, who is Executive Director for Governance and Conformity from Petrobras. Dr. Patricia is Superintendent of Integrity and Compliance from BNDES. Dr. Marcelo Pontes Viana, who is here with us also, Secretary for Private Integrity of CGU, the General Controller's Office. Dr. Fábio Galvão, who is associate of law firm Medina Osório, and from CVM, the Stock Exchange Control Agency, and legal director from BNDES, who is here with us also. They are illustrious conferencists. All are already here with us. Just some quick words to greet. For some initial words, I give the floor to Dr. Vanessa Reis, who was a prosecutor for the state of Rio de Janeiro and also associated to law firm. Thank you, Professor Fábio. I congratulate all the other speakers on behalf of Dr. Marcos, who was the first to speak. Then we will talk about many issues here. It's a pleasure to be here at BNDES, where IIEDE has the pleasure to discuss matters that are so relevant in the economic development of the country, important for the development, and we have important conclusions for our matter regarding compliance and its largest comprehension, because compliance is our day-to-day, not only in great companies, but also in our individual conduct with transparency and seeking perfection. I thank Professor Fábio. Director, let's Dr. Osório. To begin the event, I'd like to give the floor and introduce Dr. Patrícia Miguel Gouveia, who's Superintendent of Integrity and Compliance Sector from BNDES, and representing here our President Aloysio Mercadante, President from BNDES, Dr. Patrícia Miguel Gouveia. You have the floor to open with your speech, your opening speech. Thank you, Dr. Fabio. I'd like to greet everyone here. Welcome, everyone, and also my colleagues in the panel. I'd like to greet the President, Dr. Fabio Medina Osório, mentor of this event, also the Director for Governance and Conformity from Petrobras, Dr. Mario Spinelli, Secretary for Private Integrity of CGU, Dr. Marcelo Viana, Dr. Fábio Eduardo Galvão, Associate from Medina Osório Advogados, a law firm, and our Legal Director from BNDES, Dr. Walter Baelli. Also greet the audience of high qualification here at the BNDES auditorium. It's an honor to be in the event, and on behalf of the President of BNDES and the Compliance Director of the bank, as Superintendent of the Compliance Area, I thank you for the promotion and the opportunity, and for the opportunity of talking to about compliance that is so present in the Brazilian entrepreneur environment. Well, I was invited to speak about the issue of the paradigm compliance paradigm, and for that I'd like to read a short text about compliance. Compliance in Brazil faces many challenges, and it's important to approach them to assure integrity and conformity in the organizations. Some of the main challenges include organizational culture, complex legislation, corruption and fraud, high rotation of personnel, limited resources, interest conflicts, conflicts of interest, data technology, continuous monitoring, education and capacity building, and pressure for results. Apart from the traditional integrity and conformity paradigm that's emergent in compliance, this paradigm increases the structure, understanding the compliance structure classified in 3 dimensions. First dimension, integrity, ethnical grounds, compliance focused on integrity, assuring that foundations follow rules based on ethical principles. Second baseline is compliance to the legal baseline. And compliance concentrates also in conformity with laws and regulations. That involves implementation of policies and procedures to avoid infractions. And finally, finality with the teleological grounds, which a new paradigm wants to associate a new dimension to compliance, a finality or the ends. That means compliance must be structured considering social goals of the institution. In the public, we have public interest in the fulfillment of the Sustainable Development Goals, the SDGs. Well, this text I just read, applied to the present context, actually is from the co-pilot from Microsoft, which is the generative artificial intelligence. Who would say 10 years ago that we would be at an event with an audience that's so large to deal with compliance as a paradigm and recurring to the IA, generative artificial intelligence, to talk about the shift in this paradigm. Back there, talking about 10 years ago,
the programs of compliance were structured only in big companies that were multinational and majoritarily with forces of the systems, and there were not too many professionals that were interested in this. And the offer of this literature was not very big. So 10 years ago, artificial intelligence, regenerative artificial intelligence, if it had advanced as it is nowadays, hardly it would be difficult for us to find the paradigms of compliance. And for the little maturity that we have on the topic and not a lot of interest on the users, nowadays just for us to be able to extract a text that is so current on the topic of artificial intelligence already shows how advanced this is in our country. And going back to the speech regarding AI, I have brought here for us to discuss how compliance that I call compliance 4.0 is multidisciplinary, cross-cutting, and that doesn't have any boundaries. And here I present to you a picture of a few of the reflections regarding compliance, especially in our country, but also that are applicable for other countries. We divide compliance in 4 generations, and we call compliance 1.0, that is related to conformity, that we are talking about in the 90s, a effort of this agenda for the insemination and attribution of responsibilities focus obviously in the fulfillment of laws and regulations and the internal regulations that have a mitigation point of view for the nonconformity. That was the structure and the focus that we had internally with this overview of being able to think about this in a different way. So now we have the compliance 2.0, the 90s and 2000s that was focused in Basileia, which was oriented by this. Basileia brought a reinforcement of the bank supervision, and they are institutions that are regulated, as we all know, and Basileia ended up bringing this influence in this context, strengthening the vision of the different layers of the institutions. So compliance starts to be connected to culture, to the organizational DNA, for us to consider all of this, the conduct of everyone, the community as a whole. And diffusing this concept, the main focus that we have in this compliance in the 2nd generation is to digest risks and to be able to have this ethical deviation. So this was the look, the highlight that we have in this area. So advancing in the 2000s, in the decade, in the compliance 2.0, that is called this way. Here, we bring the concept of integrity. So a great stimulus of this evolution of this agenda came from the law anti-corruption that brought clearly this stimulus for the programs of integrity and compliance would be applied in the institutions. And in this context, other regulatory frameworks came to the whole legal framework of the money laundering and combat to terrorism. Reputation became a value that was completely related to the compliance. And culture started being seen this way as well. And we started understanding that compliance is necessary for the existence of the organization to maintain its relationship to its interested parties, but to establish norms as well and relationships, and also to be able to avoid a discontinuity that is identified in this relevance of the terms that are identified. Last but not least, we quote here the compliance 4.0, which is the compliance that we see nowadays. It's a compliance that is beyond borders. It goes beyond the internal look. It addresses many other topics that are not part of the scope of the compliance. And here we mention many things like the agenda of data protection, ESG, and conflict of interest. Compliance clearly is translated as the main consultant of the decision making and also seen as a governance tool. Is not a subject that is isolated that contributes, but also is a very interesting tool for everyone with the CCO's help in all the big corporations. We're able to visualize this map with the great evolution of this topic, that in the beginning, it had a very restrict look, an internal look. And now we're starting to see a multi-frontier and multidisciplinary look, cross-cutting, a protagonism that is a little shyer in terms of organization, but now supporting the decision making in all of the different levels. It's really dictating the conduct of the processes that we have, and compliance stops being seen as a cost and starts being seen as a way of making things happen. And this has been given in a very short period of time, and with a few of the factors that were mentioned by our friend here. And we have technological advancements, complexities that we're seeing, new frameworks of regulatory framework, sovereign, uh, dear agendas that we're seeing, and indefinite. This is a context of the organizational culture. We have evolved from a vision of democracy to of morality one, with morality and integrity and governance. And that's it. It went to a cost, to a value reputational overview. And here we bring in a few words to try to reflect a little bit what is the translation of this journey of compliance that we visualize in the companies that are committed to this agenda. And BNDES is part of this process. There are many challenges that we have ahead of us. And at the end of the day, I think that the great ambition of compliance is to be able to transform society. And we don't talk about an agent that is transformative only inside. For the company, not to only be a reference, but to be an inducer of good practices in its relationship chain. And in the many topics that we were able to mention before, it's part of the scope of the 4.0 compliance scenario. A company not only does business, but influences its way of good practices to be really rooted and applied in their ecosystem. And this is the great legacy that the legal people can bring to society. And for this ambition to become a reality, no one can do anything by themselves. We need a network that can bring inspiration, references, and that can be legitimate, and bridges that can have common efforts with sustainable views. And for this, we cannot stop caring about the priorities with the pillars that are the triple borderline, that are the social aspect, economic aspect, and environmental aspect of our operations. And an imbalance in this ends up having a problem for the society and for the company as a whole. And it's interesting that this speech that we call the journey of the value of compliance, if we would be talking about this 10 years ago or more, will probably not be understood by the majority of the audience. But what does this have to do with compliance norms and regulation? Nowadays, we are able to understand this as a value for society. It makes a lot of sense. And the connections are fundamental. And we continue with this journey for value. Connections like this one that we're having here, talking about BNDES, IIEDE, Petrobras, CGU, that at the end of the day, I would also like to thank the partnership that we have with Petrobras, Banco do Brasil, this trade relationship that we have when it comes to Petrobras and CGU. We have different technical exercises of straightening our agendas for the institutional relationships. And for this, I bring this reading for the people that are interested, but I would also like to mention BNDES. I work in this bank since 2015, and I remember clearly how everything started. in terms of structuring of this structure that today is with the responsibility of conducting this agenda for the bank and for Brazil. Before, the subject used to be an initiative that was conducted by the Department of Control to try to integrate the many practices that the bank already had in this area. And it's worth remembering that with this history that we have as a bank, we have a lot of pride as many practices that we were able to do in a very decentralized manner beforehand, but we were able to instigate the institutions to do an integration with the synergies of this agenda that is so dear to everyone. So I have some colleagues that participated in this process since 2015, and I'm very happy and proud to be part of this team in the bank. We have worked in this subject as an initiative of integration of all of these topics, and this initiative has developed itself in an agenda that is strategic and fundamental, with the high administration being part of this. And the subject that started in a small part of the business with different attributions nowadays. Nowadays, we have a board of risk management and compliance that works strongly in the decision making of the high administration. I'm very proud to talk about this story and to prove how much we have evolved over time in the subject. And we can also say that there was an internal revolution in terms of this culture change, and we have the serious commitment when it comes to the dissemination of the compliance internally for our employees, for everyone to be part of this relevant agenda, and externally as well. Our perception of the responsibility of induction of this agenda in society is unequivocal. So I bring here a few highlights that prove how the bank has been engaging itself in these agendas that are dear to compliance. So transparency, the cooperation agreements, all of the prevention part of CGU, with the results that we look for that are really relevant for the institution, some awards, engagements with the Global Pact, with the actions of ANCLA. So here we bring a few references of engagements of the bank that are connected to this topic, and also a indicator that is really important to equity, equality, and the different parts of the board. This has been seen with a lot of seriousness, and we have evolved a lot in this sense with definition of strategies of work policies. So the bank indeed is positioning itself in a very coherent way for seeking a coherence with this agenda. As a challenge of compliance, besides obviously working in the strengthening and robustness of the culture and dissemination, I love these agendas that I've mentioned before, human rights and everything that I have mentioned before as an integral part of the 4.0 compliance. I think it's pertinent to mention the artificial intelligence as well, that is the regenerative artificial intelligence that I mentioned at the beginning. Recently, there was a research of PwC indicating that until 2030, there are predictions of changes in the GDP of more than $300 trillion in terms of productivity of the entrepreneurs derived from this. And it's not a number that we can dismiss. So there will be a great revolution in our organizational context. So what weights our regulatory framework that has not been developed in, wholly? The Brazilian strategy that was published in June of 2022 already points to the convergence of the AI frameworks of China, United States, and so on, of this ethical part of the AI. This has to do with the risks of the social applications and the wrong use of the AI. So we need to think about the ethics by design. So the designs of the algorithms. We need to be ready to contribute in this agenda. And when I say prepared, we need to say that we're not only talking about the ethical application of the AI, the algorithms that are involved for the internal compliance of the bank, but also in the ethical use of the AI in our operation and in the fostering of the AI in our chain of relationship. This is an agenda that is really global, challenging, and compliance is part of this. And we need to really be able to establish these interactions and these conversations to be able to evolve and to cross-cut these concepts. So finishing my speech, I would like to leave this audacity view that we're seeking for a BNDES. And so this robust understanding for the sustainable role of the AI in society, this is dynamic, this is instigating, and we're trying to bring good practices in this journey of the 4.0 compliance and BNDES. I would like to thank everyone, and I would like to say that I hope that we have a lot of exchanges during this meeting. Thank you so much. I'm going to pass the floor back to Fábio Medina. Oh my. Thank you so much, Dr. Patricia, for this beautiful speech. I'm going to pass the floor back to Vanessa. Just complimenting. Thank you so much, Patricia, for this brilliant speech, talking about this history of compliance, reaching artificial intelligence today. I think this is our main challenge now, to incorporate artificial intelligence and in compliance. So now I'm going to pass the floor to Fábio Medina Osório, who is the president and the former Minister of Administrative Law of Competence of Madrid, Master of Public Law by the University of Rio Grande do Sul. He's a lawyer and former prosecutor of Rio Grande do Sul, and the president of a special commission of the administrative law of the National Council of the Bar of Brazil, and the international study of the laws of the state, and the writer of several articles of administrative law and sanctioned law. And I am an honor to be part of his office. So I'll pass the floor to you.
Thank you very much. I renew my greetings to everyone here present. Dr. Vanessa Reis, Director of Institutional Relations from the International Institute for State Studies, all authorities, speakers, and members of the panel already mentioned. It's an honor to be able to be here, organizing this seminar, and also as a speaker. Once again, I renew my greetings to the speaker who preceded me, Dr. Patricia Miguel Gouveia, especially. I will deal with compliance, anti-corruption compliance, and will take ownership of the compliance concept that is already used, or was used by Dr. Patricia Miguel Gouveia, Compliance 4.0, which is, let's say, fashionable, and try to go a little deeper into the pillars of compliance that seem to me important within what is suggested as application of this concept of compliance for the companies in Brazil. First of all, it seems important when you suggest implementing compliance to observe the norm 37,321, if I'm not mistaken. And from that premise, treat compliance as a perspective of conformity with the continuous process and resulting in the fulfillment of obligations by an organization. It's also paramount to my seeing for any organization to have as premises for compliance the norms from CGU, the General Controller's Office. Why? CGU today has a reach to inspect compliance, and this is a perspective that goes far beyond what we imagine with what has to do with contracts signed with the public administration, or a concept of harm to the public funds, so to say. This is observed in the mandatory side of implementation of compliance in the law firms, a demand that the Federal Council of the Brazilian Bar Association already considered or advisable. So on the contrary of what some some jurists may believe, compliance is not only for the firms that contracts with the public administration or participate in procurements, or law firms that deal with public funds, but also has implemented, not necessarily compliance in a model, let's compliance officer, traditional compliance officer, but a compliance to minimum requirements. It's in this construction of compliance, and the ordinance 57, ordinance 1089 regarding compliance compliance is a structured principles towards prevention, mediation, and tackling fraud, ethical conduct deviations, and the integrity program is in Article 56 of Decree 11,129 from 2022, must be observed also. And the requirements of the compliance program are basically aligned in ISO 37301 from 2021. We need to understand the to implement compliance that's adapted to the peculiarities of each organization, understand the context of the organization, understand the needs and the expectations of the interested parties, the management, conformity management systems, the obligations for conformity, the risk assessment for conformity, understand the leadership system, understand and adapt the peculiarities of the conformity culture, develop a conformity policy, adapt policy from high administration. High administration, we use this term depending on the business model, adapting to the peculiarities of the dimension of the particular organization. Can be an organization of a structure of a given dimension, a small, mid-size, small, large organization, to develop a function of compliance. This compliance function will be responsible for operating the compliance system. So the compliance culture must be adjusted so all have adherence to these obligations, and that there should be planning in order for risk management to be adapted, so the actions should approach all risks and opportunities. And then we can structure planning of the resource allocation, the trainings or capacity buildings, and management and communication. And from these premises, you can establish planning, operational control, control systems for procedures, and also the investigative procedures regarding the so-called regulation. So these investigative procedures, often we don't realize they need to obey to the principle of legality. Oftentimes we create in self-regulation for compliance a system, an investigative system that's autonomous with sanction procedures, with an conduct or ethics code that's well established, an infraction and sanction code, without adherence to the principle of legality. That's a serious problem. Why? Because these sanctions within the compliance system, they hit or they harm fundamental rights of the people who are affected. And the legality principle and the self-regulation compliance must observe legality. It's a self-regulation system, but it has to be legal norm. It's not because it's self-regulation that it can go against the legal system. So, for example, if we would move to self-regulation in the law firm, what's the legality system for compliance in law firms? The Bar Association statute. What's the legality system for compliance in given entrepreneur organizations? Then you have the laws. The labor laws with the employees. There has to be a leading legislation to fire people, or to be able to establish a regency system. You can't create the egg with a system of punishment without adherence to legality. This often is forgotten by the compliance system. They forget and create procedures simpler to be created. Very well. And then the compliance system must have a continuous enhancement, and it also must have development of performance assessment, monitoring, continuous measurement, development of indicators, the conformity reports, maintenance of records, internal audits, and also external audits. External audit is frequently forgotten, and continuous enhancement is paramount. Now, when we look to the anti-corruption law 2246 from 2013, we have to visualize three basic functionalities of compliance, anti-corruption compliance. Well, one paramount functionality is the attenuation of compliance. This component works as a reduction of penalty, and to reduce penalties, it will work with given instances, these control instances or these control sectors that are multiple and apply anti-corruption sanctions. Not only the General Controller's Office, but the institutions that are competent to apply anti-corruption law. Petrobras is competent, BNDES, in many instances have the competence to apply the anti-corruption law. The states, the municipalities, all institutions have the competence to apply anti-corruption law because they have the competence to reduce sanctions considering compliance. Compliance has a second function, to my seeing, that, by the way, is not only, that's not only my opinion, but it's a function that's already consolidated in the jurisprudence. The function to rehabilitate, function of rehabilitation of the company that's in the jurisprudence. So in other words, effective compliance as a prerequisite to rehabilitate the company when it suffered some penalty. This function is very important. Why? Because when a company suffers a sanction, was disabilitated, so to say, compliance works for rehabilitation ends. That's consolidated also, especially in the controller's office and many opinions, the CGU. The threshold for penalties from the Supreme Court jurisprudence and the opinion from CGU, like opinion 00282 from 2018 from Conjure, from Federal Prosecutor Vinicius Carvalho Madeira, among many others, that the threshold for penalty is 6 years, according to the Supreme Court jurisprudence for rehabilitation. So you can transform compliance into a demand that goes over the threshold of, or the penalty can't be perpetuous. It can't be a life penalty, can't be used as a life penalty. So compliance effectively can be conditioned in one penalty as a formula for the rehabilitation of the company, but it can't, the company can't go over the 6-year threshold, period threshold to be penalized. So there are many precedents in this sense. So the Delta case, for example, there were many cases. Penalty can't be perpetuous or a life penalty, and lack of specification of damage by administration is another problem that creates a distortion of perpetuous penalties. So it can't be conditioned to the presentation of compliance, because eventually, for example, the issue of rehabilitation, if the company is not able to present an effective compliance, it remains without rehabilitation for an undetermined time. So it will have a penalty for inhabilitation and a conditioning for rehabilitation by the presentation of an effective compliance for an ungiven time. So that happened in practice until the jurisprudence of the Supreme Court said the following: look, when the penalty is conditioned for an undetermined period of time, this can harm the principle of the prohibition of perpetuous penalty. Why? Because the penalty has an undetermined character, because the company remains inhabilitated, remains with a condition for ungiven time or undetermined time to an effective compliance, so she's inhabilitated, let's say, for 2 years, and still under the condition of presenting an effective compliance. So maybe these 2 years go by and it keeps slipping until it presents an effective compliance. So many years go by, 4, 5, 6, 7, 8 years, and an effective can't be presented, and we don't know how long the company will take to present an effective compliance. It can spend 10, 15 years without ever being able to this presentation of effective compliance would be a way of creating a perpetuous or
a Constituição Federal veda pena perpétua. Não pode ter pena perpétua, nem pena de caráter indeterminado. E a própria CGU também, nos seus pareceres, o seu entendimento, e a CGU tem aí grandes juristas que passaram pela CGU, como foi o caso do ministro Navarro,
the case of
Marcelo
Navarro,
e que
Navarro point that
passaram a entender
also
que essa vedação da pena perpétua não fazia realmente esse compliance, essa exigência indeterminada do compliance efetivo não teria sentido. Não teria sentido. Teria que delimitar um prazo, um teto de 6 anos, que é os 6 anos que você pode exigir. Porque, claro, faz sentido ter um prazo, digamos assim, ter uma limitação para a empresa, para operar no mercado, ela precisa ter um compliance efetivo. Então, a exigência da reabilitação de um compliance efetivo faz sentido para uma
effective compliance makes sense for a regular,
como é o caso da CGU. Então, faz sentido, muitas vezes, condicionar, além da pena, além da inabilitação, condicionar para a empresa voltar ao mercado ter um compliance
so the
efetivo,
company
como é uma das funções do compliance. Para a empresa voltar ao mercado,
to impose a condition
compliance efetivo. Aliás,
effective compliance to
licitações cada vez mais têm aumentado
so the demands in
exigência de compliance efetivo. E me parece razoável isso. Então, também aí é o conceito
also
de compliance efetivo,
they have the
precisa ser bem estruturado.
compliance that has to be well structured, but with this limitation. And then we move to the third functionality of effective compliance, which is more complex. And I want to greet Walter Baelli here, who is here with us, a great jurist, legal director from BNDES, one of the great thinkers that will do our closing conference dealing with in its comprehension.
Vamos tratar da questão do compliance com a sua funcionalidade na
compliance with the functionality from the
E essa é uma discussão que ainda
of the cause nexus has not been enough
mas talvez
in the Brazilian legal
o compliance com uma funcionalidade de ruptura
with
do
the
nexo causal no tocante à
breach of the
efetiva,
cause nexus in the
uma imputação contra a pessoa jurídica por organização
person
defeituosa
by
no seu compliance. Quando a imputação for
in its
por
compliance.
culpabilidade por organização defeituosa no seu compliance. Quando a imputação for dessa natureza. Então, nós temos essa
we have this
raciocínio de que
line
a
of thought
responsabilidade pode também gerar responsabilidade à luz da teoria funcionalista do direito administrativo sancionador. A pessoa jurídica pode ser responsável por riscos proibidos gerados na sua conduta e na valoração de determinados deveres, na dimensão das suas atividades, por uma culpabilidade por organização defeituosa. Então, nesse caso, pode haver a partir da assunção de determinados riscos proibidos, uma imputação de resultados lesivos decorrentes de um compliance defeituoso. Nesse caso, se a empresa comprovasse o compliance efetivo, ela poderia se eximir dessa responsabilidade, especialmente, talvez, até na questão dos ilícitos ambientais. Seria possível, talvez, valorar aí nessa hipótese. Mas seria um avanço nesse sentido, para a responsabilidade objetiva. Seria, talvez, considerar o compliance como um mecanismo excludente de nexo de causalidade da responsabilidade
Compliance
para fins de estimular como um mecanismo de incentivo para que as empresas adotem o compliance. O investimento na implementação do mecanismo de compliance para evitar determinados resultados lesivos.
Harmful.
Então, para fomentar benefícios de longo prazo. É óbvio que
It's obvious that
não seria uma situação
wouldn't be a situation
todos os ilícitos, porque a
for
regra geral
all
do
the
compliance
illegalities,
nessa
because the
tríplice
general rule that
funcionalidade, que ele opere nessa tríplice funcionalidade, em geral, como uma atenuante de penalidades, por outro lado,
reducer,
na outra
and on
função
the other
de
hand, in the other fund,
reabilitação, mas excepcionalmente como
but exceptionally
excludente de
as an excludent
responsabilidade.
of
Portanto, o que nós temos
what we have
ainda a destacar
still
é que o compliance
highlight is
efetivo
effective compliance
tem como
has
elemento central
as a
também
core element
um compliance
also
officer independente,
an
mas
compliance
eu
officer,
destacaria que
but
para
I would
determinados
highlight that
modelos de
for given
compliance,
compliance
dentro das
models,
peculiaridades da organização,
priorities of the
como seria o caso
organization,
para o compliance nos
as it would be
escritórios
the
de
case of
advocacia,
compliance in law,
é óbvio que esse
it's
compliance
obvious this
officer
compliance officer
poderia ser um compliance
could
officer
be a compliance officer
na figura do titular do
in
escritório de
figure
advocacia, por exemplo,
of
porque nós
the
teríamos aí
responsible of the head
a confidencialidade das informações, a
of
relação de
confidentiality
fidúcia
of information
entre o cliente e o advogado. Em
and
muitos
secrecy
escritórios de uma dimensão
from
pequena,
law firm.
não haveria sentido em ter um
There would
compliance
be
officer
any sense in
independente.
having
Aliás, também as microempresas
compliance officer.
ou
By the way,
empresas de porte
small
menor, não haveria sentido em ter um
size
compliance officer
companies
independente. Para muitas
would need an
organizações,
independent
um
compliance
compliance
officer.
officer
For many
independente teria um
organizations, an
custo que não
independent
se
compliance
justificaria.
officer would have a cost that
Então,
wouldn't
mesmo esse
justify itself.
conceito de compliance
So
officer
this, even
independente que nós
this
sempre
independent compliance officer concept
defendemos,
we always justify and stand for
é um conceito que se
is a
justifica para
concept that
determinadas organizações
is
que querem
justified for
esse
given
fluxo.
organizations that can
Porque para
support the
outras
burden,
organizações,
because for
esse
other
conceito de
organizations,
compliance não se
this
justifica.
compliance models is not
Então, o
justified.
que é o compliance para
So
quais
what is
organizações efetivamente
compliance
ele
for
se
what
adequa, ele
organizations?
se justifica em
Can it
determinadas
be
tipologias?
adapted or can be
É para todas
justified
as
in a given
organizações, quer dizer,
typology? Is
é
it
para
for
todas as
all
tipologias de
organizations? I mean, for all kinds of
o que é
companies,
um compliance? Nós formos
what
entender
is
um compliance, um
are
conceito
these
mais vasto,
compliances?
a pessoa pode ter a
Compliance under a
noção de
broader
compliance
concept
pessoal,
can have even a
o
personal
cliente de uma
compliance
organização
kind of
pequena, de
organization
pequeno
that is
porte,
small,
isso é
small
algo muito
size. This
artesanal.
is something
Esse
very
princípios
artisanal.
nos quais
This
ele
is
é
a concept that's almost
compliance.
ethical.
Então, se nós formos pensar, ele tem que ter uma
So
relação
what
com
we have to think
custo-benefício realmente que
is
se
to
justifique.
see a
Portanto, quando nós estamos
that
pensando que o Conselho
is
Federal de Ordens de
justified. So
Advogados do
when
Brasil
think
hoje
the
já
Federal Council of the Brazilian
recomenda
Bar
compliance para
Association
todos os
recommends compliance
escritórios que
for
estão
all the
funcionando,
law firms, we're thinking
há
that
inúmeros escritórios
there
de
are
muita
law
modéstia
firms
no Brasil,
that are
escritórios muito modestos,
very
aonde os
modest law
advogados
firms,
imaginar
lawyers,
que os escritórios
to imagine
se
all
regulamentam
law
como
firms
escritórios de
should have compliance, law firms that have an extremely modest economic size. So if you recommend for all on something by in the cost-benefit ratio that would make sense for the Brazilian population for a given economic class could be really implemented. So we're thinking that should have make sense. So we have to think nowadays in the phenomenon of massification of compliance also. Compliance is a phenomenon that can be massified. So there are many, and this cost we have at ISO
na ISO 37301,
37301
muito elástico. É conceito que
concept
permite
that
justamente
allows exactly for
Instituto do Compliance para múltiplas organizações. Seriam fundamentalmente essas as minhas reflexões para esse fenômeno do compliance que vai permear, digamos assim,
compliance, which will
os próximos anos na sociedade brasileira, como está na Europa, como está nos Estados Unidos, porque se nós pensarmos bem hoje, o compliance permeia a ética, permeia as nossas relações pessoais, permeia as relações dos jovens. Vejam, eles mais ou menos se relacionam pensando como eles são monitorados pelas câmeras, como eles são monitorados, como eles são filmados, como eles têm que se comportar. A sociedade é uma sociedade digital,
is
uma sociedade
now
com a imagem, das redes sociais, e o compliance fundamentalmente também é isso. Muito obrigado por estarem aqui. E muito obrigado por nos prestigiarem.
Thank you very much for
passar para a próxima. Obrigado.
We'll move to the next speech. Thank you.
Professor Fábio Medina, thank you so much for your class about this effective compliance. Thank you so much. We understood and this posture that needs to be closer and closer to our reality. So I'm going to pass directly the floor to Professor Patrícia. We're going to invite the next speaker, Marcos Glauzio Spinelli. Dr. Mário Spinelli has a vast curriculum. So Dr. Lucas didn't leave his complete CV here for me to read, or else we would occupy 2 hours here speaking about his curriculum. But he has a comeback to corruption trajectory here in Brazil that is well known by all of the Brazilians. He has gone through the municipality of São Paulo. He has a public career, and today he occupies the governance and compliance of Petrobras. He's a PhD in the FGV of São Paulo. He is master in São Paulo administration in Minas Gerais, and it's indeed an honor for us to hear from him and have the trust and friendship from him. He's one of the public most prestiged and qualified people in this matter in Brazil. Thank you so much for being here with us in the seminar about the paradigms of compliance in Brazil. Thank you so much. I'll give you the floor now. Thank you, Fábio. I would like to thank the organization for the invitation. Fábio Medina Osório, and everyone else. I would like to thank BNDES for everything, and to thank everyone on the table as well. It's an enormous pleasure to be with you today discussing this topic. So the organization was really happy in choosing this topic, talking about the paths of the compliance for our country. What we need to think regarding a positive compliance, where we came from, where we're going. So I'd like to start my approach giving you a question. Who here acts in compliance? Who does compliance in the public area here? And in the private area? Perfect. So we notice, and I have done this provocation because we notice clearly in this history that Patricia brought in such a clear way regarding compliance. I always like to give this analysis, this historic analysis, where we come from and where we're going, this big companies and so on. And it's a great threshold for us in 2014 on. And now we are in a forum where the public and private sector are discussing things in a very similar way, looking at things that are very similar. So my approach here, I haven't even said this with Patricia before, but it's what Patricia has said about the role of BNDES and the challenges that we have been facing. Our board will complete 10 years at the end of the year. It was created at the end of 2014, at the moment that Petrobras was going through a very hard problem, when we had the money laundering operation, and as a response, we had the creation of a board that was going to take care of this compliance. And now, celebrating 10 years since its creation, it's necessary for us to look at the past, to look at what we have done and what we can do from now on. Because I think that more and more compliance assumes activities and attributions that at first weren't part of our routine. So if in 2013 we had this great moment, compliance before for big companies, for regulated areas like us, the banks and so on, the anti-corruption law was established, and it was established for companies that didn't have programs for integrity. And if they didn't have that, this established that they could have punishments that could be annulled or decreased, and there was this environment for compliance to be disseminated. In 2015, 2016, compliance was focused on anti-corruption. The focus was that. And after a while, a series of new attributions were given. So now we have a challenge that is not small. When we talk about compliance nowadays, it goes beyond the anti-corruption. Of course, it's important, but we need to look at the operations and harassment combat, which is very challenging for any sector, for public and private sector. And we need to think about the data protection, and this is also established in our constitution since last year. We have to look for issues that are related to the ESG agenda. We have been able to make it Brazilian, this term that started ESG and now it's ASG. So there is a role of attributions that makes the professionals that act in the area be more knowledgeable of this, because before it was really limited to the corruption, but now it's much more broader. So what have we done in Petrobras? The organization of the event has invited me, and I was really happy about that. And I would like to thank Walter, the legal director of BNDES, Marcelo, secretary of CGU, of private integrity in CGU. And the objective here is to bring the Petrobras model based on this reflection that we are proposing here, which is to think about the new paradigms of compliance in Brazil. So what are we doing in Brazil to adapt the companies for this new context that compliance is assuming with these new attributions? Last year, we had done the first restructuring of our board, and it dialogues a lot with what we were talking about regarding these paradigms and what Patricia has brought in her intervention initially. So the idea here is to present a little bit of what we do and what we propose to do in this new context that is given. I always play around. I am a professor in Getúlio Vargas in São Paulo for graduation and for a master's degree. And we had 80 people there. And we were talking about combat to harassment and moral harassment, sexual harassment, and so on. We need to also think about electoral harassment as well. We have been seeing in the journals and in the articles that this is something that has been manifested as well. Are the companies ready to avoid electoral harassment as well? In the last election, we had companies that were harassing their employees to vote in one or another candidate. So this is a challenge that we need to face. Are the codes of ethics with predictions for that? So I was talking a little bit about that yesterday with my students from FGV, and who thinks that this is going to stop happening? They're wrong. It's not something that we can leave behind. So if no one thinks about this, they're going to lose market. There is a generation that thankfully do not tolerate certain conducts that in the past were common conduct. So the organization can be public or private, but they need to be prepared for that. Crisis of reputation, crisis of image are already there, and Petrobras is already thinking about that. There are crises for the reputation, and you know how much this has costed for us. This is more or less the dialogue that I intend to bring to you in this brief intervention that I'm going to give today. I'm not going to detail the story, but just to register. We have in Petrobras a board that is dedicated to compliance. It's a board that was created until the end of 2014. This year, like I said, there will be its anniversary for its 10 years. And we're going to do a celebration related to that. And this is an area that was able to be aggregating activities in Petrobras. We are 8 directors, and this group that composes the executive part of the company is a central nucleus of our company that gives us the importance to be part of the board, but also a responsibility, because we are the first board that has a veto power when it comes to agendas that have to do with sexual compliance. And we are in the biggest company of Latin America when it comes to this market, and with this task of decisions that involve billions of lives. And we usually say that there is nothing that can be less than $1 billion in our company, because we have budgets that are always really big. And to have this system of compliance that is designed for it to work well, but also to make the company not lose efficiency, is a big challenge. And this is what we have been working with. I would like to thank our team that is here with us and representing Petrobras. It's a pleasure to have you all here discussing, dialoguing, and thinking about outside the box. we always need to do this. And this different way of thinking is really, really important for us. So I confess that this restlessness is really important, and I really like the integrity systems. It has become a chapter of a book that I have written about this. I think that the concept of integrity goes beyond compliance. So if compliance, first of all, it has a lot to do with the fulfillment of norms. We're talking about this. But when we think about integrity, we go beyond that. We're talking about a set of structures, of norms, of instruments, of management and control that try to make the organization be more transparent, be more ethical, be able to fulfill the norms, but also to be able to have policies for social responsibility, to look at people and to have respect for people. So I really like this term. We are building this system of integrity that goes beyond being in agreement with the norms or not. And our structure is really bad to keep talking about structure, but I have just brought this slide just for you to understand that it tries to talk about the topic of the seminar, because today, if someone asks me what I think about the new paradigm of compliance, I think that the new paradigm of compliance is, beside talking about corruption, is to talk about some other things, like I said before, the harassments and discrimination, capacity to investigate, respecting people. Just giving you an example, but we are used to investigate fraud, and now we are investigating harassment. Today we have received complaints in our ombudsman's channel. We have more than 200 per month, and now they're always related to violence in the work. And now we have this perception that this needs to be combated and this needs to be investigated. So sexual harassment is different than the ways to interview the people is different as well. The proof is different as well. And many times the proof is one, the word of one of the other. So these are the evidences that we need to deal with. So when we have in the private area the harassment cases, it's really common for the people to disconnect this person before that is over. So when there are no lawsuits that are effective, we cannot do that in Petrobras because it's a removal of a person with a fair cause. So we need to have robust investigations and to be able to do a fair investigation, a fair trial. So it's completely different, the interviews that we do. So it's a huge challenge for the organizations to take care of this type of issue. When we talk about investigations today, we have a discussion that goes beyond what people first used to perceive as important. Now we are discussing, for example, the harassment cases or the moral harassment cases when the victim doesn't feel harassed or when a third party reports a case. Do I have the duty to investigate that? Because this happens. A third party says, oh, there is a sexual harassment for that other person. And when you interview that person, the person says, no, I wasn't harassed. Do we need to investigate that? Is that the duty from the organizations to investigate that? That type of debate is something that we need to do to deepen our activities. So this is one of the greatest challenges that we have. And another great challenge that we have, which is to work with tools that are related to science of data to perfect our activities of compliance. Today, we have tools that are really powerful and that need to be incorporated to the compliance case. Just to give you an example, Petrobras is an engineering company. There are norms for everything. There are rules for everything. We have 26,000 internal norms, and we have rules even to go up the stairs. I play around with that, but for example, if an authority is going to give a lecture, they need to go up two steps, and he doesn't do it the right way, it's an infraction. So there was a shame that we went through in Brasilia. We were in an event in CGU in the Apex auditory, and we went for lunch. There was a car from Petrobras waiting for me and saying, "Oh, let's go in the car of Petrobras." There were 4 people there, and the driver said, "Look, director, we can't go in 4 people." Why? Oh, it's just you and 4 people. And no, there's an internal law saying that we cannot do that. There is a norm saying that we can only go with 3 people besides the driver. And I didn't know this norm. And the driver taught me. So I had to ask for someone to clarify that, but we had to go with a Uber or in a taxi because we couldn't go with that official car. So there are norms for everything. And it's an industrial company that sometimes acts in a very unsafe place, a very difficult platforms that are very difficult for us to enter. So we need to be prepared about these different norms that exist in the company. And today we have tools for mining data and processes that allow us to identify irregularities in real time of things that have left the store. So, for example, if I have a payment in my payment flow for the organization, I can use this tool to detect a payment that was outside of the normality in the system. There is a red flag. And at that moment, I identify what happened. So we need to incorporate that in compliance. We need to be able to work with data, with indicators. And I need to know if I am training people regarding moral harassment or discrimination, which is another problem that we have in the companies. And if I increase the number of complaints that I have in the company, the complaints that I have, there was a huge crisis regarding sexual harassment. We already had a system where we were able to understand the different harassments that were happening, and it was not enough. All of the news were already talking about that, about the sexual harassments that were happening in Petrobras. We had to remodel the way that we were investigating things to understand what was happening. And with that, people started talking about that. What happened the year next? That
you can interpret that in 2 ways. The number of claims increased because people were more comfortable, or they increased because the number of harassment, amount of harassment increased. We have to have. In this case, I have the conviction that it increased because we were able to develop awareness in people and they felt more free to report things that were going on for some time. One of the things we did was have a channel for caring, for receiving the reports, and so the famous tripod that compliance always used to establish itself: prevention, detection, and remediation. The harassment, in harassment, it's not enough. You have to have care, you have to have transparency, and say you're punishing, which is a major challenge. A company that works where employees are hired in the general labor regime. For CGU, Marcelo, people are punished. It's publicized, and that's why, that's the cause. It goes to the official gazette, and then there's a registry. What's the name? registry. Yeah, punished people. Yes, there's a registry for punished people. In Petrobras, I can't do that because the labor general regime doesn't allow for that level of transparency. So how do I inform people I'm punishment when I have to punish people for corruption, fraud, harassment? So it's a little bit one of the challenges we have. What did we do then? Was prepare our sector for this new sector, these new paradigms for compliance. So we created a specific area to work with data science. This area will produce indicators. This area will work with data mining tools, science applied to compliance, work with indicators, since the most basic ones like time to investigate a report. What's the average time I take to investigate? What's my level of punishment, for example, of companies? One of the areas we created, accountability or for disciplinary measures, the area that cares for responsibility of employees as well as companies and accounts rendering. And also today we are the entity that most applies sanctions in the country on law. Petrobras has over 200 million reais of fines applied to companies. We answer for more or less something around 20% of all the sanctions applied in the country based on the anti-corruption law. So we have been very severe when applying the law. I have to have an indicator regarding this. What's the percentage of the fines I'm receiving? Is it because if I'm receiving little, is that because the companies are taking the cases to justice or because I'm not collecting properly? So very little people nowadays work with compliance indicators. We still use data science, very little applied to with regards to compliance. So in our sector, we have 4 executive management, 1 for governance, which is in Petrobras, we join conformity with governance because the decision process is intimately connected to compliance. We have a compliance itself, an internal investigations area, accountability, personal data. One of our managers is in charge of the personal treatment, following the general data protection law, and another for data science. So I've mentioned this. We created the internal corrections office. We created last year a management that's specialized in work and deal and investigate with cases of harassment and prejudice. This unit was selected. We had a woman leading this sector for an obvious reason. Women are the main victims of harassment, and Petrobras is an extremely masculinized women. 83% are men of our employees. We have a small LGBTQI plus. It's a small percentage, but this parcel is important. We talk about prejudice, for instance. It's a masculinized company. We have to train people so we can stop any kind of prejudice. This is disrespect to people, and respect to people is a pillar. It's assigned in our strategic plan for the next 5 years, respecting people and tackling any kind of prejudice. Well, I've talked about the use of advanced technology. I think, as I mentioned, it's a huge challenge. When we created that area, we did a selection. We made a selection to choose the leader. And one of the one who was selected is one of the largest specialists in the country. And I told them we have a huge challenge. We are placing all the chips in this sector, and we can make compliance have more abilities of performing in simultaneously with management and providing quick answers. Well, I'm reaching the end of the presentation, but I think when we talk about compliance, it's important to also mention governance, because in Petrobras, governance has a paramount role. Why? because we are a mixed economy society association. Sorry, it's a state company. It's a mixed economy association. There are public and private interests in the same space. How to make these interests minimally aligned, or if not, that the decision-making process should protect the interest of the controller, stockholder, federal government, and the minority stockholders. Because when we talk about minority stockholders, we have to remember that we're talking about all audiences, since a major stockholder that has a lot of stock, large investment funds, until the small stockholders that sometimes invest his savings of years of work to buy shares of the company. So you have to have very solid governance in order for these interests to be protected by our decision-making process. So what did we build in terms of governance model? Our governance, we have the January Stockholder Assembly. Petrobras has over 700,000 stockholders. Our administration council has 11 members, presently 5 appointed by the controller, stockholder, 1 representing the employees, in 6, 1 and 4, 6 from the federal government, 1 representing the employees, and 4 the other stockholders. And then we have instances that will guide this decision-making process. Regarding governance, we are responsible for the definition of the rules for governance. So we have our rules for competence. So some decisions can only be taken by the directory board, and others can be done in a management, executive management, but all decision-making process, this was built to privilege collegiate decisions, collective decisions. So I recently said in an IIEDE event, in Petrobras, nobody decides anything alone. And these decisions are must have technical assessment done by specific committees previously, and they will lead the decision-making processes. So when it comes to our executive board meeting in Petrobras, sometimes it lasts 12 hours. Begins 10 a.m., sometimes it ends 11, 12 p.m. So these meetings have the opinions from the technical areas, all that to privilege technical decisions in this arena that has so many interests involved. So this slide talks about this a little bit, this decision-making process, this governance model, and for that we have to follow rules which are established by the market, or also rules established by the government itself. Nowadays, we follow 94% of the good practices of the Brazilian Corporate Governance Code. We only not follow 100% because 6 are not applied to Petrobras because it's a state company. Otherwise, we would be following 100%. We are at the highest level of corporate governance indicators because of the need for Petrobras to be aligned to best practices in terms of governance, and that has direct impact over compliance, because if we don't have a robust decision-making process, things bust at compliance. So our model is a known model. I won't talk about this. I'm reaching the end of the presentation. Is designed based on the 3-line model, the 3 lines of defense in the past. More recently, they were renamed the 3 lines. First, control is done by the manager itself. We're the 2nd line. We contribute to the design of internal controls. We follow what's done. And the 3rd line, in our case, is developed by our internal audit, which is also does the auditing inspections and is, like us, connected directly to the administration board. So the conformity in governance director, in my case, the internal auditor and the internal ombudsman are positions that have a mandate and are connected directly to the administration board. In my case, interruption of this mandate can only be done with the majority of the board and majority of the representatives of minority stockholders, so protection, so the director can work with independence. So there we have a set of rules for compliance. We work on the most diverse fronts, since the most preventive part with our rules and alignments. I always like to congratulate the team. We have very good workers who produce materials. We have a chart. If you don't know it, I invite you to find out about it, about sexual and moral harassment and prejudice. I think it's the best material produced in the country about this matter. It's super easy to understand, and it's very beautiful. It has good diagrams and very consistent from the theoretical point of view. It's very good. Many companies say this material is very, very well done because the team that works there, and many of them I see here in Petrobras, it's good, easy to do things because people are very good. When I came back to Petrobras, I said, how good it is. There are many good people. Our team is very qualified. So we have our ethical conduct code that's going on by a reformulation. This year, we're doing it in a participative way. Employees from Petrobras are contributing. Process will last a whole year because people contributing, they feel they have a feeling of belonging. We have a specific code for providers. We have our compliance policy. So, talking about prevention and support to decision-making in practice, one of the tasks our area does most is issuing opinions about conformity. So many decisions in Petrobras are they must have a compliance opinion. We analyze compliance, norms, training, for companies to sign contracts with Petrobras, they must have robust compliance. We've done over 33,000 analysis of companies regarding their integrity. We check many issues if company have a robust compliance, depending on the risk they represent. And from last October, we began including in this analysis human rights protection issues. So companies to do business with Petrobras, they have to have personal data protection. There are many things. We are drafting a program, and my employee doesn't like me to mention it before it's ready, but it's to stimulate and collaborate with small and mid-sized providers so they can develop compliance, and we will help them. We will share our capacity building material. So the small companies, because our chain of suppliers is giant, we have over 230,000 suppliers registered, and we think we have an important role in fostering integrity in this supplier network. Our corrections environment, I won't talk about this. We have a correction system that's pretty robust that goes since the reports up to investigation and application of sanctions. And to finalize a little bit of our numbers from last year, so you have an idea of how this area is robust. Our EAD for prevention, tackling prejudice and which issued more than 39,000 background checks. We do a background check on all who will have management positions in Petrobras, had the participation, it identifies conflicts of interest and legal barriers, and we did over 5,300 evaluations. It says 1,676 opinions and guidance from our unit, 1,056 reports or complaints, claims investigated by the field, by the area. The year 370 integrity assessments, and huge number of administrative processes against companies. And last slide, to finalize, we have an annual poll for compliance. Every company that has a well-structured compliance has to do this to identify what must be done to enhance its actions. We have 27 questions asked to employees at Petrobras, done as from an independent institution about our actions. Since the question, if I know about something irregularity, so I report it. If I think my boss is works right, and since last year we have the largest rate of favorable opinions. We went over 40%, providing us very good feedback of how the integrity culture is disseminated in the company. And Petrobras ended up winning kind of many awards last year. Good practices in ethical by the Public Ethical Committee award. Here's the representative to prove this. We were the only company awarded in the 5 categories of the UN Global Pact for companies. This is the recognition of this work. These were my contributions trying to talk to this title given to the event. I'd like to thank everyone for their attention. Thank BNDES for having me here once again, and I thank my friends for the invitation. It's a pleasure to be here with you. Thank you, my dear Mário Vinícius Spinelli, for the brilliant speech. I'd like to invite you to remain in the panel so we now can watch the speech from Marcelo Pontes Viana. I'd like to call to the panel, Vanessa, if you allow us to have Marcelo here. Marcelo Pontes Viana is Secretary for Integrity, private integrity at the General Controller's Office, CGU. Welcome, Marcelo. He also has a very vast resume. We'll summarize it. He's a federal auditor for finance and control from the General Controller's Office, Secretary of Private Integrity of that ministry. He's a specialist in national economy by George Washington University, in public law and assessment of public policies by the University Center of Brasilia, UniCeub. He's a master's in law by the University of Notre Dame, Master of Laws, and is really a reference in the General Controller's Office in Brazil in this field of sanction, administrative law, and compliance. So it's an honor for us to receive you, to have you here, Marcelo Pontes Viana, to talk about compliance under the in the General Controller's Office. Thank you very much. I am the one who thank you. Good morning, everyone. It's a pleasure to be here at this event. I'd like to thank Fabio and Vanessa for the invitation. Greet also the speakers who preceded me, Marcos, Mario, Patricia. Thank you for the generous words. I usually say I am at CGU for a long time and eventually at the wrong time, wrong place, and to face some challenges that were pretty large. My trajectory with the corruption line begins basically at the moment we need to begin negotiating the plea bargain agreements when we had the Lava Jato operation. It was, we were beginning in CGU, and straight away we had one of the cases that I say up today were the most challenging, most complex till the day. So more recently, CGU created a specific unit to gather all the areas related to the application of the corruption law. So the private integrity unit has the main goal fostering more integrity culture, especially in the entrepreneur private sector, but also naturally in other private institutions. And for that, having especially the instruments of the anti-corruption law, but also some other fronts we have worked with during these years and that are already considered future challenges. Within the unit, we have all the area of investigation and processing of company involved in corruption cases. So this is done with accountability procedures. In CGU, we lead the cases considered of more relevance, more complexity that could be would be better off led by us instead of the institution where the illicit procedure happened. I will talk about that, but we also do the supervision of the processes done by other institutions to assure a standard of procedure and application of the law that's the most uniform possible in the executive federal branch.
So it's also this discussion that we have already followed for many years. It can be consensual, and in this promotion of private integrity. So we also have our board that has its private law to regulate and establish what we understand as being the entrepreneurial understandings, and I have a greater power to tell you a little about this. These activities are within a great program. Although we work with responsabilization and investigation, we notice that all of this is part of the promotion of private integrity. So to do a private integrity investigation comes with different types of way of sensibilizations of understanding. So we need to do that with only one policy. So when we do this type of policy of private property, we need to understand our vocation a different way in the application of fights and understandings of conductor of behavior. And here we have a challenge, and I'm going to tell you a little bit about this afterwards, which I don't want to drop the level, but there were some things that were really interesting regarding the interventions. Patricia has mentioned about the evolution, the perspective of the compliance, talking about the different types of approach. And you have also provoked a little bit about how the state can select the behavior, establishing legal ways of compensation and recognition of compensations that can happen in the private sector. What we believe is that the public sector's promotion of equality can help in the private sector as well. Everyone here probably knows that the concept of integrity related to ethics, honesty, and other types of behavior that we consider the most correct ones on behalf not only of the individuals but of the organization and the companies is something that is growing a lot. And I like to remember that this is not something that is imposed by history. It's something that we don't even have to go a lot many years ago. The society doesn't tolerate behaviors that are against this. So for many years, this type of behavior was tolerant, like slavery, child labor, and land degradation. So for us, it scares us nowadays, but we don't even need to go too far in history. But our society tended to think this as acceptable, and the standard that we have today, thinking about integrity, is not only thinking about doing right for the right thing, but also to think about the perception that doing right is better for the economic development and the social development. And this concept of the entrepreneurial development and of society development, it's what we give a value for our company in terms of trade and the efficiency quality of your services that you want to develop. So when we think about the social development of the country, it's not only about benchmarking, but also to understand that we're part of an ecosystem that is integrated and that we're making privilege to the consumer, to the development of professionals that can act directly in the institutions. And I think this is a virtuous cycle. So when we recognize that they have a function that is part of the society, that they are not an isolated agent that act in an exclusive way, only thinking about profit, they understand that they're going to have a long-lasting life and that will last longer, their businesses as well. So the social action is also really important for them. And when we think about the inducer of integrity in the companies, it's fundamental in this way of behaving. So we have the privilege of having worked in the greatest institutions that we have in their country, which are the institutions that generate richness, and they have a public function as well. And we recognize with a lot of pride how much we see this as a motor of change in the integrity behavior. We have been doing a development of technical cooperation that envisions this improvement of this behavior. And as provider of development, we also need to look at the ones that are conceiving the credit. They need to also think about the demands for the credit providers to also adopt these promotions of different behaviors. And Mario has also given a very important speech talking about this hiring people and establishing this requisite of behavior as well, and understanding the discussion that the great corporations have regarding this behavior. So I'm really happy because Mario has already talked about this, the possibility of Petrobras aiding the partners of as medium, small size to develop behaviors that are um, also whole and important. So our perspective, this relation of the integrity in the sector, the private sector, is not something that we need to expect the private sector to do that by themselves in a more altruistic way. We recognize as CGUs that the state has a fundamental role of creating the conditions for the private sector to be able to recognize that it's worth to act this way. So for many years already, CGU has already recognized that the state needs to provide this recognition, orientation, and to repress the wrong conducts that are intolerable for the private sector to see that it's worth for them, their business, to adopt behaviors that are more related to integrity. I like to put this point here because it can seem obvious, but it's something that at the world level, something that our government has been doing is something that is worth understanding, and this stimulation and repression whenever possible is something that we have been exporting for the international organizations that and meetings that we have. Patricia has mentioned, and I think that Mario as well has been talking about some initiatives that are global, like the Global Pact. So the stimulus that the global institutions have been giving for the companies to reach these objectives for the Sustainable Development Goals, and that have been established in the SDGs. As part of this process, what does Brazil have been doing in the world forums? Show the governments that they have been doing this, and that the other governments have to provide these orientations, providing recognitions of good practices and repressions that Mario has mentioned as well, or Fabio has mentioned as well, because the conduct need to be recompensated in terms of what they have been trying to promote in more programs of integrity. Even if they have been doing something that is illegal, we need to think that they have um, something that escaped the control, but the control exists, and that they were trying to help the most. So to differentiate a company that is doing a stimulus for the integrity and another one that doesn't have that haven't been doing that. What does this have to do with the conferences that we have been being part of? Well, the ones that are signing the anti-corruption law of the UN is reviewed every 2 years, and the countries discuss what can be done in terms of advancement, in terms of combating corruption. And our proposal, it was submitted to the plenary of the UN at the end of last year, establishing what is the role of the state in terms of integrity in the private sector. And it was a resolution that was really well accepted in this meeting, and it was proposed by Brazil, and then it was subscribed by many other member countries, and especially the European community. And based on this resolution that was proposed by Brazil, we have established guidelines that are going to orient the countries in regards to what they have to do. This is just to say that we are exporting models, and we have advanced a lot in that. And this idea is still very small. Brazil is presiding the G20 group, and the G20 has different subgroups and different topics to discuss. And one of them have been doing has to do with the combat to corruption. And CGU is presiding this group this year. And one of the products that we're going to deliver is also the greater detailing of how the countries of G20, the greatest economies in the world, can serve as reference of inducers of best practices in this dialogue. So when we bring these jurisdictions and these different perspectives, we need to think about what are the countries that understand that the state action needs to be only in a different way, and some think that the private sector needs to establish their own parameters. We have been fostering this specifically in countries that have a greater development, that the role of the state needs to be more proactive. It needs to be justifiable in terms of the private and public institutions that will result in a greater understanding of for the economy. So we expect until the end of the year that we approve this document in terms of the G20 that touch this point. This all to reinforce how current this topic is and how much this has been part and reverberating not only in terms of forums like this, but in multilateral forums as well in several countries. So as I said before, our actions here, we think that we need to act in repression, but we orient what we understand as being the best standards of integrity. We also act in different stimulations, but we also need to act in the repression part whenever possible, necessary. So I have inverted a little bit of the information that I'm going to pass to you, because it's necessary to recognize that Brazil, in terms of responsibilization and recrimination, has turned keys of perception that Brazil is very tolerant and very slow in terms of responsibilization, with this lack of punishment sometimes. I have brought here a few data related to how the responsibilization has grown in terms of the companies since the addition of the anti-corruption law. I know that many times all around the world we have some isolated sentences that people mentioned and that weren't well successful, but it's important for also to have a good perception that legislations that are really important regarding anti-corruption have been done well. Sometimes they need to ripen themselves a little bit, and some need to be corrected, but we cannot fall in the wrong perception that there isn't an institutional improvement. But here is just one of the data that I can make available for you in regards to what I think it's a good institutionalization of anti-corruption, and they are really significant too. Mario has commented that Petrobras is responsible for a great amount of the numbers that are here and the processes of responsabilization that were conducted in the executive power, and 1,500 acts of anti-corruption have resulted in a total application of 17 billion in the executive, and 4 million of them were conducted directly by CGU. Just to highlight that CGU, although it only does 1/4 of this trials, it's also always responsible for the greater volume of them because of the cases that have most relevance. So we cannot forget that, yes, we need to stimulate and orient, but whenever possible, we are the strong arm of the state to act and make responsible who are responsible for each one, and to exempt people that are necessary to be exempt. Like I said in the beginning, the objective here is not the responsabilization as an end in itself. These numbers here, they're not numbers that we have as a goal or something like that. We need to show them as a takeaway for the society, but we want to change the behavior as well. That's why I said that one of the things that we have advanced a lot in CGU are the means of resolution of alternative trials and sanctions by themselves. Why am I saying this? Because there's an extensive use of the program of lenience that establishes this for the companies, and that the company needs to assume their responsibility and to collaborate and to have behavior change. We are in this semester with the agreements of lenience, and this is our global numbers regarding this perspective, that some of the cases that have been under discussion here in some of this forum in the Supreme Court, that represent a small parcel of these agreements of lenience. So the agreements of lenience is a instrument that was established in the anti-corruption law, establishing that the company that is going to show and collaborate that with the state will have a more favorable treatment to the ones that are not assuming their responsibilities, and there will be a change. They won't have a change in their behavior. When this happens, there are 27 celebrated agreements of lenience by the federation that have been already done in the order of 18 billions, and 9.4 were effectively collected back to the public budget. So although they are big impacts, the adoption of the programs of integrity are monitored by the team of CGU and external auditors. So their commitments that demand the return to the public coffin, so that we also see a change of behavior and an improvement of the measurements of control. In here, I didn't bring the specific slide regarding this, but we have advanced beyond the agreements of lenience with other mechanisms of resolutions. And just to explain to you that besides these requisites that I have already talked about, the admission of the responsibility, the collaboration with the state, the strengthening of the programs of integrity, there is a requisite that is extremely specific about the lenience agreement, which is the one that is destined for the companies that have the condition to help the state to make responsible a number of agents that are able to provide this information to the state and to improve the consensual investigation. So with our experience throughout these years conducting this responsabilization process, we have been able to have situations that were in three spectrums. We had a spectrum that was for the companies that didn't admit their responsabilization at the beginning, or that wanted to continue defending their right. We had on the other spectrum the companies that would agree with the lenience process and would be successful. And there were other companies that wanted to assume their responsibility, that wanted to see the need of changing their behavior, but that didn't have proof or testimonials or other ways of proving their innocence. So they admitted their innocence and they wanted to change their behavior. But in the absence of this instrument, we constituted in 2022 a new tool of consensual resolution, which is anticipated agreement, which was really well received since 2022. We are going to complete 2 years now in August of this year. There were more than 70 requests for them, and there were some of them that were already resulted.
But has an effect and expectation of behavior change that's much larger, because for me it makes more sense that the company that took the commitment of change its behavior and pays what it owes have a chance to change in its institutional way of working, strengthen its programs of integrity, than the ones that keep on litigating and is forced to pay for the sanctions. Going more towards our guidance field, I believe many of you know our chart in CGU from long time, and we believe very much in the dissemination of knowledge through guides, through capacity building. During these years, we have been ahead and having the main manual, which is the integrity program, guides and guidelines for private companies to establish. What I can bring you in terms of spoilers, that this year we will update that guide. It's in the final phase of validation, so we can bring newer concepts, so we can have more integration of these aspects. And we have been creating more customized guides related, for example, to small and mid-sized companies, like the guide established with SEBRAE, guides for companies that work abroad, like the case of Apex Brazil. Case guide that was very well known in the market is the practical manual for integrity evaluation in this guide has upside of graduating the integrity in the companies. It's a true extensive checklist that has been used as a reference in capacity building programs as to what the state requires in integrity programs. This guide is in a final phase of review. I was closing with this with my team. One of the requirements I asked the team was that before we launch this new prerequisites, should be submitted to public consultation. So we understand that the exchange of experiences and the perceptions and informations with the ones in the private market, but others that work in the public space about the theme, can make that document even more valuable. So we hope next week this will be placed under public consultation, so all the updated materials, so you can do the contributions in terms of what can be enhanced. There's a large expectation of talking to the perspective that Patricia mentioned in terms of the integrity program be something that goes beyond simply preventing corruption acts, and be a paradigm for the institution, so it can work within compliance and the principles that guide the organization. So it will be here. I ask you dearly to contribute with this document. If you can follow the CGU network, social media, I'll leave you our website. We will publicize this, expecting having inputs to enhance these guides of ours. All right. Well, everyone, beyond providing guidance, we believe in recognizing good practices stimulate other ways for private companies, and I will briefly quote two of our main initiatives in terms of fostering private integrity in a voluntary way on behalf of the companies or on the side of the company. Since 2011, we have Prática program that I believe you must know in your majority, because it's really a program from the government that was consolidated as being one of the major goals the companies that have integrity programs that are well established want to reach, which is the recognition and obtaining the Prática seal. It's a public tender through which CGU breaks the opportunity, so the companies submit their integrity programs for assessment. We trying to recognize best practices in the market. At each edition of Prática, we place more demanding prerequisites so we can award the companies that have been doing this successfully, and that the market can see this company is committed to the best integrity parameters. When I stepped into the unit, one of the main criticisms to Prática is that it ended up limiting the participation of institutions, companies that were still beginning in that journey. They looked to Prática and said, well, this bar is too high, this level is too high, I won't be able to do this in the short term. I'd like to have something to begin this journey with. And in the idea that the state has to be really a foster these good behavior practices, we launched at the end of the last year the Pacto Brasil initiative for the entrepreneur initiative. It's a collective movement, and I can do we do a provocation to private companies so they establish a public commitment in the sense they are committed with this integrity trajectory. So how does it work? Pacto Brasil, diferente from Empresa Prática, doesn't involve an evaluation on part. It won't be evaluated by CGU. What does the company that subscribes to the pact gains as benefit? Apart from being brought, publicizing, it's a company that has the seal. It'll be able to access CGU e-platform made available in March for self-assessment. So everything we have in terms of instruments for guidance, how we assess companies, will be available for the company so it can respond voluntarily to the requirements. It'll see, CGU asks me for a given aspect. Do I have it? No, I still not. So I don't take it. Or this one I do have. So it can have a feedback of how it's being placed in the CGU's bar. Something I must leave clear when I talk about Pacto Brasil. The assessment, the self-assessment, has only one goal: serve as a thermometer for the company itself. CGU won't do any use of this company to harm the company, and it won't be publicized unless the company authorizes us to publicize this. What we will use in Pacto Brasil is the statistical analysis to try to place the companies and see their difficulties, where they can be have more adjusted support actions. But Pacto Brasil is a movement for fostering companies. We have established partnerships with other institutions like AOS Institute to Global Pact, so they can support the companies that adhere to Brazil, so they can fulfill that journey, and so they can have a more feasible goal in the end of the journey, so they can be candidates to Prática company and be well evaluated in this recognition. For the ones here from the integrity sector and the private sector, I do a provocation and make an invitation so you find out about Pacto Brasil, assess in your company the possibility of being adherent. This has no cost, and in the counterparty, the offers opportunity for the company to show it's engaged in integrity practice and have access to a system that nowadays is charged for by many advisories. Here you'll have a governmental tool without any burden, any negative repercussion that the company will be able to use automatically. Finally, I'd like to have talk about the last issue, because my time is almost over. of another role CGU has tried to work in fostering integrity in the private sector. So just a quick legal aspect, apart from corruption, it's recognized as a norm that really drove very strongly in terms of perception that private integrity is important. But at the same time, the corruption line doesn't create obligation for any kind of integrity. What it creates are indirect stimuli. For example, creates for fearing sanction. It establishes for the company, look, it would be better if you have an integrity problem to avoid your objective responsibility. So if you perpetrate a harmful act, and if you have the program for integrity, your penalty can be reduced and you can be a better candidate for a plea bargain program. And what we lack, some provocations were very well done. If it would be the case for the legislation to establish that there is an integrity program, if having an integrity program would break the cause nexus. And I mentioned this because there were other laws in Brazil before talking about compliance anti-corruption program mentioned by the law 2246 for financial institutions. Compliance was already an extremely well-absorbed theme because mainly of the counter money laundering law. And this law has a different approach. It says that regulated sectors and institutions have to have an integrity program, a compliance program mandatorily. The absence of a program can be a cause for accountability. So I like this digression regarding the two fronts because in 2021, we had the approval of a new procurement law that had a different approach regarding stimulating integrity programs. And here recognizing, like Petrobras has been doing, that the state as a contractor has a very important contract in inducing behavior. So when it decides with who he will establish the public contract, who will be its provider, and I don't need to highlight how much the state is a major contractor in terms of public procurement, it will establish the ones he will sign contracts with. The new procurement law brought things related to private integrity in at least 4 contexts. So it established in the context of large contracts that overcome values above 200 million reais, and that's updated annually. It's in about 240 million now, say establishing a new paradigm, establishing that you who are a large contract subscriber must have an integrity program mandatorily. Now it's not a stimulation or an option, it's an obligation, a condition to keep that contract with the public administration. See, this is also a way of stimulating integrity differently than the 2486 did. A second issue that is brought in the integrity program, it establishes as being a criteria for of a best proposal. If a company is in a tie, the one with the integrity program will prevail with regards to the one that doesn't. So here, a tie in a public procurement. So it's benefit the law has this integrity program as an upside in a public procurement. Also, there's a reduction of penalties foreseen in the public procurement law, and also a criteria for rehabilitation. Professor Fabio mentioned the challenges regarding to this. The company that suffers penalties, if it wants to anticipate its sanction, it must have an integrity program to require for rehabilitation. These providences by the law as still must be regulated. This regulation was prepared by this General Controller's Office with the Ministry and awaits for the President of the Republic's signature, I can give you some spoilers as what we're suggesting with regards to this decree. Challenge, when we mention it's a demand for a public contract to have integrity programs, is the issue of and working for
do administração pública são algumas centenas aquelas que chegam em valores de contratos públicos.
There are hundreds of large size contracts. Who is going to do the evaluation? What parameters will be used? So the approach we're suggesting in the decree is that in the first moment, the assessment of these programs will be concentrated in the General Controller's Office. And why in the General Controller's Office? It's a way of approach where we still will verify how it will happen in practice. So before we
para as outras organizações públicas, a gente quer conduzir projeto em que a gente consolide esses parâmetros, que a gente teste esses parâmetros para depois poder ir passando para os órgãos públicos que também têm contratos de grande vulto. Iremos olhar todos, iremos olhar aqueles que nossa capacidade operacional permite. Então, aqui a gente vai ter uma abordagem baseada em riscos, ou seja, vamos olhar o universo de contratos de grande vulto, aqueles que apresentam maiores riscos em termos de integridade, para selecionar, dentro da nossa capacidade, aqueles que a gente vai poder avaliar com maior profundidade. A nossa abordagem aqui não é uma abordagem repressiva, do tipo, a empresa ganhou um contrato de grande vulto, ela tem 6 meses para implementar seu programa. Com 6 meses, nós fizemos uma avaliação desse programa, ele ainda não está adequado. O que nós iremos fazer? Trabalhar junto com a empresa para que ela chegue no que seja adequado. Deixar a questão repressiva para o último momento, para a última instância, quando, sim, os casos demonstrarem, no caso de uma fraude, de um documento, de uma apresentação de informação falsa, aí sim seria o caso. Mas a nossa abordagem aqui, ela tem essa vertente muito mais de promoção do que necessariamente de repressão. Questão de desempate. Marcelo, são centenas as licitações, são milhares as licitações que acontecem. Quando eu conversei com a MGI, eles falaram, olha, Marcelo, a empresa aqui, quando ela está participando de um pregão, ela já coloca ali quais são os critérios que ela entende que ela atende para fins de desempate. Se ela é um microempreendedor individual, se ela tem produção nacional, todos esses requisitos eles já são automaticamente lançados por ele, de forma autodeclaratória, e depois avaliados. Como que a gente vai conseguir fazer uma avaliação numa situação que a empresa declara um programa de integridade para solucionar uma disputa numa licitação que está acontecendo ali em tempo real? Colocando isso em situação, num exemplo hipotético aqui bastante concreto. Duas empresas empatam no preço, empatam em todos os critérios, uma declara que tem programa de integridade. A gente vai parar a licitação para avaliar aquele programa de integridade para depois ter continuidade? Isso não seria execuível. Então, o que a gente está propondo? A gente está propondo que a empresa ela vai fazer uma autodeclaração de que ela tem um programa de integridade. Essa autodeclaração será feita por meio da adesão ao Pacto Brasil e o preenchimento da autoavaliação. Se ela assim o fez, nós depois teremos um universo de empresas que se valeram dessa prerrogativa, que estão passíveis de terem o seu programa efetivamente avaliados. Se a gente conseguir avaliar todos, ótimo. Se a gente não conseguir, a gente vai avaliar também por critérios de risco e materialidade. Não é muito diferente de outras formas de atuação do Estado, Receita Federal, todo mundo aqui, acredito, acabou de mandar o imposto de renda. A Receita Federal não vai olhar o imposto de renda de todo mundo, ele vai olhar de acordo com seus critérios de materialidade e também de formas mais automatizadas. Então, nesse sentido, o Pacto Brasil também procura ser um estímulo, um diferencial para quem for participar de contratações públicas. A gente espera que nos próximos meses esse decreto ele já seja publicado para que ele dê continuidade a essas ações do governo de maior promoção de integridade junto às empresas. Bem, dito isso, eu queria reforçar
I'd like to reinforce the public consultation we are going to do in terms of nowadays our evaluation, if we take them as a whole, taking Pacto Brasil as the and plea bargains, they are prerequisites that are 11 depending on the situation, they can be.
Vou explicar pouquinho mais por quê. Aqui são os pilares do programa de integridade, é a forma conceitual como a gente insere cada um dos quesitos de avaliação. E por que eu falei que podem ser 10 ou 11 a depender da situação? Como a Patrícia colocou muito bem aqui, hoje a gente fala de integridade para além apenas só de questões relacionadas à anticorrupção. Para a gente, na CGU, é um desafio tratar desse tema, porque a gente está falando da possibilidade de aplicar a estrutura de programas de integridade para tratar de outras matérias com as quais a gente não tem um domínio, não tem o conhecimento todo técnico para estabelecer o que seria, por exemplo, um programa de integridade que protege direitos humanos, um programa de integridade que observa a responsabilidade socioambiental. Mas nós já estamos desenvolvendo que uma grande área de avaliação de programa de integridade tem justamente a ver com a sua responsabilidade social, ambiental, de direitos humanos e também requisitos de transparência. Como que a gente está fazendo isso para superar esse desafio técnico que é nosso mesmo, de se apropriar desse conteúdo e não correndo o risco de, primeiro, exigir demais, de modo que a gente coloque um ônus excessivo sobre a empresa e isso acaba não surtindo o efeito que a gente deseja, ou exigindo de menos, de modo a ser algo que é simplesmente para mostrar e não promover alteração de comportamento. Então, a gente tem estabelecido aí parcerias com as diversas instituições públicas e privadas para debater
Partnerships with public and private institutions to debate the theme in its many fronts. We open for discussion.
No âmbito do Conselho de Combate à Corrupção e Transparência e Integridade da CGU, CTICC, Conselho de Transparência, Combate à Corrupção e Integridade.
Corruption and counter corruption, and for integrity and integrity, there's a private integrity issues. We hope to fulfill social responsibility in group. In the Brazil Pact, we have done that movement. So the ones that can look and have interested to look the assessment form for the Pacto Brazil will see that this is one of the prerequisites included. It's the path, it's to where the integrity measures are going, and we hope to keep inducing in that sense. Just to finalize, I leave my invitation for you to visit the website of CGE, just for private integrity. Apart from the guides, information I made available for you, you have access, for example, to all the process administrative procedures, so you know how companies are being held accountable, how the sanctions are being applied. I didn't bring a slide, but we launched in the end of last year a document, I think, not a document, a panel, BI, with information that I consider very important for the ones working with development of integrity programs. From the last edition of Atricon, where we assessed 255 companies, we created large recognition, because from the evaluation of each prerequisites, we see where companies, how companies are performing, where they're doing better, where they're having more difficulties, and that is your disposal. The evaluations are anonymized. We only know the companies that won the seal, but all the others, in an anonymous way, their assessment is there, so we can remove some super interesting diagnosis. For example, we verified that the largest challenges the company has in terms of integrity is due risk management. So this is a challenge that is posed, that you can see inclusively in the forums you want to participate in, an organization where you can concentrate more. So I don't know any other research that has created that much information and that much science that can be consumed. It's in our website. Make good use of it and criticize it. Mainly, we have we've used criticism pretty much. People say what needs to be better, what is. So this is very good, so we can deliver more products that service society better. And that's it. Thank you once again for the invitation and the participation.
I would like to thank Marcelo Ponce Viana for this brilliant intervention, and I would like to invite Marcelo Pontes Viana e Mário Vinícius Pisinelli to be with us for in the lunch in the sequence of the event. The Institute is going to offer this to everyone that is here on the table, okay? Thank you so much. And the invitee to come to the table. So, Fábio Eduardo Galvão.
Próximo conferencista. Advogado.
The next one is a lawyer. He's associate to a law firm. He is a manager of CBM and also of Medina Osório Advogados. And he's going to do an intervention that is going to be really quick. So he is a reinforcement manager of CVM and the economic sectors of the public administration of Getúlio Vargas. He's a leader auditor and 37,001, and he's a member of the distinguishment. Fábio Galvão is going to do his lecture in 20 minutes, and then we're going to watch the conference of closing of Walter Baeri that we're waiting anxiously for this moment from the BNDES.
Fábio Galvão, para sua conferência, 20 minutos. Logo na sequência, tem a conferência de
and in sequence, we are going to have the approval of this. So actually, I would even like to ask him to be on the table with us.
Obrigado, Walter. Pois não, Fábio Galvão, obrigado. Obrigado, é uma honra tê-lo aqui conosco.
It's an honor to have you with us, and you are a great reference in compliance for us. I thank you so much as well, and also to give continuity here and divide our time really well. I would like to comment about the certifications and this matter that complements integrity. We're going to talk about the norms of 37,000 and subordination that is going to substitute the 19,200. And for those who had contact with this PDCA, that is really well represented here as well. This norm came to certify the compliance. So these are contents that are distinct, but ISO 307 is going to incorporate this anti-subordination part. So the compliance, we always see a different definition. This definition talking about this continuous process that needs to generate a result of adequation of the organization. It's something that is in the norm 3761. So that's why I put it here, because it's already normatized by this ISO. So I'm going to advance as well in this integration of the systems, because the norms talks about this as well, the needs for us as the this other about the bribery, anti-bribery law. So this integrity, which is another subsystem that we have been working with in the other system by Mr. Medina, all of the systems complement each other, and we're going to see how this is dealt with. So what is valued in terms of the compliance for us to understand what are the types of obligations that we're talking about, that we're tackling here. So in this last part of the speech about bribery, the definition of bribery that we have in the public attorney's office, we have a reference in the 307 of the Penal Code, and direct or indirectly, it's unduly charged. So this is related directly to the public power, and that is tackled here in the international norms, and that talk about corruption and about bribery in this different distinction. So we see here this integrity of CGU that we're going to talk about specifically regarding what compliance in the international norm will approach. So in this first moment, I would like to bring to you these benefits. Maybe this is just mentioning something that we already know, but compliance is a reduction of the punishments of the financial risks, so the decrease of the sanctions. So in terms of the reputation of the systems as well, we're going to talk about this too, and about ethics as well and integrity. So this is not new to anyone, but it's put here in the norm, and it's something that we have been given as a prerequisite, something that we are going to have in an effective compliance, proving that you have fulfilled the requirements. So it's an annual evaluation with the requisites that we want to face with all of these requisites in the same way that we have in the norm. We have all of the components, and we're going to approach this quickly. So mainly regarding this prevention to fraud, this is a benefit without a doubt of those who adhere to the norms. It's an alternative way for CGU because it's really connected to the damages and to the public entity. So this is something that we have in the injuries committed to the public entity. So this is something that we see in the map 12,840. So we're going to enter a lot in this injury against the public entity. And in this introduction, the norms obviously are developed in terms of international standards. And we need to say here about the process of the entrepreneurial process. The anti-corruption law promotes the entrepreneurial integrity and certification, the process of certification of the companies. It's not the technical body, it's not the owner of the company, but the company that is being certified. So this ISO specifies what are the orientations. I have a guideline here regarding how we increment this with the private companies, and this norm is in Annex A that provides a guidance and orientation and the maintenance of the bribery and injury and the compliance law. So there is a guideline as well, and this is not only about bribery, it tries to approach general practices that are broader than the integrity and of bribery as well. Another thing that was mentioned here by Dr. Medina is the how broad this law is. It will get public and private entities, and also companies of small and medium size. So I'm not going to specify here. I think that you can identify all of the hypotheses of bribery, but it's a broad range that goes beyond the international relationship with the public sector that will tackle the relationship between the public and private sector. Another thing are the requisites of the ISO 3000 and the 3761, and this adaptation of the quality. It's something that has had a similar nucleus, but it's important for us to take into account. It's a public policy that is going to be communicated and generated in this effort of diffusion of the culture of integrity and the risk evaluation issue that was put here by Marcelo Pontes. It's a huge difficulty that we have with the water management issue. So it was already mentioned as well. There's a number of years that we have with indicators and the risk evaluation. So this is essential. So we're going to bring this as the most important way possible. And the controls, the financial controls, and this is going to go to our accounting firm and so on. And in the case of Petrobras, and so these controls are really important. And just to advance, and the more materiality we see in this, we are going to deepen in our investigation and to do the subordination. So we're going to think about the segregation of functions that Petrobras is doing as well, and the importance of the internal auditing. It's a process of retrofitting the compliance. If we want that, we need to go through the auditors sector to see if we have things to improve or not. So it's a continuous process of retrofitting in this evaluation. CGU has a panorama that is really interesting in terms of impact, and we can do this checking, and we can do that in terms of certifications, and the auditor is going to go in each place, is going to require information. You're going to enter the computer to show what you have there. It's a different perspective. So the steps to implementation, we're going to have a differentiation, and I'm not going to enter into details because we don't have a lot of time. But in the conclusion, I think that we're going to tackle that as well, and this changing of culture as well. And the designation of this function of compliance, what is this? When we have an organization, several agents of compliance, not only the director, not only the compliance officer, but in each area, we have a compliance person fulfilling the ISO 371 and the program of integrity, which is so important. So it needs to be decentralized. And this is the function of the compliance. And then, once again, as well, the part of communication, of training, which is going to reinforce this mentality and is going to force this compliance methods. So I have also talked about what happens in terms of responsibility of the implementation of the program, of the internal compliance, the audits that we need to do internally, especially with the areas of control that we have, and also the accounting firms, the federal offices. So this spectrum of control that the public power has, it's really important. And portal that also is really important in this area. It's the directive portal. So I'm going to skip here to optimize the time, but the advantages are really clear. The reduction of the crimes, the reputation. I'm not going to repeat here because Marcelo has mentioned it really well. The presentation is going to have a superposition, and that has been clarified. So there's this timeline that we're able to analyze. The ISO, this figure of the PDCA is tripartite, and the area of certification was a species of suspension. So it was a level for those who start in an ethical form, but we have several companies that are certified, and this data of the public power are already in the area of CGU, but in the case of ISO, it always talks about what are the companies that are certified, what are each types of norms, and the interesting data is that we still do not have the 2023 one. So we still don't know what are the companies that are certified by the ISO of compliance. These companies have already started certifying, and there are companies that are from Brazil that have already been certified, but we still do not have the quantification of that. So once again, mentioning the objectives, the principles. The principles is not going to bring this in general, but the implementation starts in the first chapter of the ISO form to understand the context of the company. So it has to do with the sector, with how this is organized, and we're going to see that the governance, although with dialogues with the compliance and with this, it's not a requisite. It's going to help in the implementation. We have the ESGs with the translation that was done by Petrobras, and we know that this is going to reflect in the interdependence. It's important to highlight that in the anti-corruption law, there is this need for this interdependence. And how is this demonstrated? Not only in regards to how this is adopted, but also in terms of the governance. So wherever we have this structure of Petrobras, for example, it's really dense and wonderful. But if we don't have a directive board, there is no hindrance from us to do this norm to be fulfilled, because we're going to go in another direction, and we're going to see who is the owner of the company is going to be in the administration. So we're talking about medium and greater big size companies, and we have to have auditors, the structure of Petrobras, for example, and the big companies of Brazil. We still have to make this commitment to be demonstrated. And in here, if we have this board, this observation is important. They need to participate. And this is what Petrobras has shown. This decision level that is higher, there is a compliance standard or document. So the part of these that I've mentioned before, there is this process for knowledge of the risks, and for us to advance as well, this evaluation of the matrix of risk, all of the processes need to be mapped and analyzed with the impact. We're going to have all of that there. And the main points here are the part of the bribery, and when we go to the program of integrity, we're talking about corruption. It's a smaller spectrum that the ISO 37301. I'm going to go really quick here. They're going to provide many subsidies, but these requisites, they are basically limited to this point. So we're not going to advance a lot because of the time, but if you open each one of them, you can see that there are policies for each one of them that we're going to measure, and there is a way for us to do that step by step and to support the ISO and so on. So I would just like to conclude, and I'm going to skip a few things because of the time. But the subtitle here is going to show the following. This is the 37301 that is specific for the compliance. The one that is lighter, it's for the other law. So I'm going to pass here, and when we see terms and definitions, we see components and requisites that need to be proved from the index 1 to 10, and the norm varies in a small part, where what is pink is a specific of compliance and what's blue is what the anti-bribery one. And just to conclude, here we have the advantages that are already commented here. In terms of the new law of public tender, we have this great this rehabilitation and these other situations that are implied here, and we also have a stimulus for the company to have the compliance implemented. In many states, they have already implemented this norm. So we're going to have the state of São Paulo, Minas, Pernambuco, São Paulo, Espírito Santo, Santa Catarina. So at least 2 of the states have already done this adaptation, and we have an extraordinary 141/140 that talks about this, the establishment of these rules of compliance by the entities of federation at a level that is lower than the federation is not unconstitutional. It's constitutional to establish it by each state and by the city halls, by São Paulo, Curitiba, and so on. They have their own demands of compliance and that are enforced. So concluding, we know this need for certification, and if we had more time,
we could talk more about this, but the important thing is that you have a private model now to show you have effective compliance. It's not only stuck, companies that need to show they have compliance with public administration, they will go by CGU, but the ones that want to prove that before city halls and state administration, that one path is the certification company that can be outsourced. And the demands will be in each regulation of each entity, a municipality, state, and some still have the mentality that this is only to be presented before a public institution. So make resources available, investment in technology, personnel enough, so it's not all concentrated in the compliance officer. That's a problem, but you have the solutions, and the solutions are going through the path of private certification, which will give you the reputation, the proof for effective compliance, and these certifications have really shown an increase in trust, especially when they use so an increase of trust in the stakeholders. That was it. Thank you for the opportunity, and I give the floor back to you, Professor Medina. Thank you, Fábio Galvão. Always a very deep view, synthetic over the subject by a production engineer and now a lawyer. Now we move to the closing conference by Walter Filho, a legal manager of BNDES, Deputy Executive Secretary of the Ministry of Planning, Fostering and Management, Doctor by the University of Coimbra, Portugal, a jurist, and a reference also in the subject of this subject in Brazil. For our pride, our honor to enlighten our seminary. You have the floor, sir. First of all, I'd like to greet all the women here with us on behalf of Dr. Vanessa Reis, greet Dr. Marco Antonio Ribas, Legal Regional Director from Banco do Brasil, for your participation in your speech. Dr. Mario Vinicius Spinelli, for the leadership of the Integrity Program, Compliance Program in Petrobras. I think Petrobras is not a pride for Brazil, but an example of a company that learned with its own mistakes and lessons and transformed this into a substantial increment in governance. Dr. Marcelo Pontes Viana, also, thank you for your speech, for your words. He's ahead of such an important program to promote integrity in the private sector of Brazil. Dr. Patricia Gouveia, who also made an excellent speech on behalf of BNDES and our integrity program. And finally, Dr. Fábio Eduardo Galvão, for your kind words. And finally, my dear friend and reference, not only in administrative sanction law, but also for doing this excellent event. I will be as brief as our hunger and time allow. I promise not to be boring. I'd like to bring a more prospective perspective and the challenges our compliance program can face, go into a little more detail, but I'll spare our stomachs and the timing of all the details. So I'll bring only a few reflections regarding the challenges of integrity programs that we face. First of all, talking about integrity under the BNDES perspective is talking about development. There is no developed country, and as our statutory mission and goal is to promote development, in Brazil, we foster economy. There's no fostering economy and having development as an ideal paramount goal. That's provided by our Article 3 of the Constitution without talking about integrity. Integrity is not only promoting anti-corruption practices, but it's the promotion of an environment for competitiveness that will create a more healthy market and the production that's more efficient of goods and services for the population and the people. It's an exercise of citizenship, an exercise that is in the core of our development program, and we have to face it. And I take the opportunity to greet the initiatives of the General Controller's Office, Minister Vinicius, that has been doing public campaign on behalf of good practices and counter corruption in our country. And talking about integrity today is not only talking about the consolidation of the advancements we obtained and advancement in the concept of anti-corruption measures. It begins with the ideal of ethical behavior in companies and internal practices to tackle corruption, but today there is a challenge that reality imposes, which I will divide into three parts. First, an environmental challenge, considering the climate emergency. So everyone that is ahead or works with integrity nowadays must at least have access to a report from the Intergovernmental Commission for Climate Change from the UN and realize the state of climate emergency we are in. Not only the tragedy in Rio Grande do Sul state here in Brazil that we're dealing with this creates an immediate sense of solidarity with our Gaúcho brothers that face the climate catastrophe and its consequences, and the images show in a very crude way the extension of the devastation provoked by the climate emergency state, but it's the recurrency and the intensity of these climate phenomena that will establish to good measure the development of the good practices in the economy, and the integrity programs will be massively and deeply impacted by the climate and environmental agenda in their essence. Second dimension is important, and that creates a present challenge for the programs of integrity, is the advancement of AI technologies in all means, all areas of production, scientific, industrial, in this quarter of humanity. AI will offer first the challenge of regulation of ethical use of these tools on behalf of companies, and this is a theme of integrity. It can be a tool in favor, but also the malicious use of algorithms to potentialize the compliance, the fake compliance programs, the ones done just for appearance, but behind they show non-ethical behavior, and AI will potentialize the control and about integrity that we must think of. Third challenge and analysis is the advancement of the individual data protection laws and the incorporation of these mechanisms, the ones that suppliers or data like us who work in the financial system and in the frontline companies and people having their data available for our performance. The treatment of this data not only begins being also the preservation of fundamental rights, rights for freedom of who the companies relate to will be in the core, and will have more and more concern with the integrity programs, with the protection of the biometric heritage or genetic heritage of people, or genetic assets of people we deal with. We'll have in the health area companies with compliance programs that will have to look to this reality of the data use and the way they manipulate those data under the perspective of integrity and ethical performance and good practices that are concurrential. Those to me are the three major challenges for the compliance programs. Integration of the agenda, and this will be more and more permanent, but the climate issue will be cross-cutting to these programs, and society will demand from company the management of this risk. For the financial system, especially BNDES that work in fostering, it's paramount to know the environmental risk and the climate risk a given client represents. Financial system had about 45 billion in assets presently in companies in Rio Grande do Sul, and the size of the systemic risk in a climate catastrophe is so large that we can't talk about climate agenda, energy transformation, change in industrial standardization will come from this premise, this reality, so that you have an idea of the size of the drama. We are in an above the average of 1.5 degrees centigrade in temperature increase with comparing to the beginning of the Industrial Revolution. So we have now 1.6 degrees in temperature in degrees in temperature increase. And if we keep on in the same trajectory, we can get to 2050 with more than 2.5 degrees increase with comparing to the beginning of the Industrial Revolution. This is an average, so extreme temperatures will also will vary between one and the other. And to feel the size of the problem, with 2.5 degrees centigrade of increase, the Amazon biome is not sustainable anymore. Desertification or savanization process in the Amazon region will begin. This is just so you know what we're dealing with and how this will impact the integrity activity. And the companies have difficulties in the present scenario with risk management. Imagine adding to this the component of climate risk as something relevant for decision making in companies. So draw your attention to this, because the General Controller's Office adds in its integrity private program the theme of social environmental responsibility. Law 14433, as mentioned here in the budgetary guideline law, has as a specific obligation to financial institutions, public institutions, like after 30 million financing, they demand integrity programs for the companies, and all the issues of how to certify themselves and how to be verified begin being crucial in our activities as public financial institutions. The sustainable regulatory agenda has been definitive. The CVM has incorporated international regulations through its ordinance. So in the stock market, there's information available on criteria of sustainability in companies, in their practice and day-to-day work. Central Bank of Brazil imposes social responsibility policy, environmental, climate policies, and not without reason, the risk of the financial system will consider investments being in risk areas and be affected or not by climate events, or being more or less resilient investments because of climate change. And these criteria must be incorporated in all and any methodology of integrity programs that intend to be resilient and face be long-lasting and face the challenges of our realities. In regards to technological evaluation, digitalization transactions, recently the EU regulated principles on ethical use of AI. They, in good part, were incorporated in this legislative proposal, the Bill of Law in our National Congress, but it's an urgent discussion theme, how companies will adopt in their integrity programs parameters for regulation and parameters for behavior that consider the ethical use of the softwares or AI for the algorithms. More and more, the algorithms will replace the human activities, and the use ethical use and the righteous use of these tools will be core to any compliance program. Same time, we see an expansion of norm production and regulatory production in terms of integrity affecting all programs. An example is the regulation of communication of safety incident. More and more cyber risk will also be part. And with AI, this comes with a sophistication component very strongly because there is some risk of the systems and prevention controls are weaker and weaker considering the strength of new cyber attacks and personal data leaks, and regulation and legislation are interconnected and depend on each other, and personal data treatment and preservation of privacy in the relationship of companies with society. As a foster bank, when we look towards integrity programs and financing, we need to more and more think on methodologies and systems for analysis and evaluation of this kind of risk that weren't in the origin of the integrity programs, but can impact their advancement definitely, and even the survival and use of these same programs. And following examples of good practices and expansion of this concept of corruption and anti-corruption measures, we've had the opportunity of listening from CGU about the initiative, so I won't go deeper into this, but I'll say BNDES has the commitment. We are in the final phase of formalization of the adherence to the Brazil Pact, and won't be an adherence only from BNDES to care for its good practices, but be an instrument of public action on behalf of an ethical and more righteous environmental environment. And we are doing this together with this General Controller's Office to formalize this issue. There's an amplification of the concept of corporate integrity, as mentioned, an incorporation of the ESG agenda, social responsibility, governance, and human rights. And as mentioned here before, nothing happens if it's not through governance. The ESG agenda begins with governance, then with social environmental responsibility, responsible social environmentally if doesn't have a commitment.
Então, é necessário cada vez mais uma integração eficaz e sinergia entre os diversos aspectos e camadas de governança das empresas e, sobretudo, comprometimento da alta administração, desde a alta administração até todos os colaboradores com as práticas de integridade. Não adianta uma alta administração extremamente comprometida e os empregados não aderentes a um programa de compliance como um todo. Daí a razão pela qual é importante um programa de comunicação e treinamento claro das instituições em relação a esses temas e aos desafios futuros também que vão ser incorporados nas práticas das empresas, porque elas vão gerar ou diminuir valor para essas sociedades cada vez mais. Aqui o BNDES, ele no ano passado foi eleito de forma independente em um painel que contou não só com auditores da Controladoria Geral da União, mas de tribunais de contas estaduais e do Tribunal de Contas
Accounts Court
da
and
nós fomos agraciados pelo da instituição pública mais
were awarded with the seal considering us the most transparent public institution. This leaves us very proud. We have an active transparency program, a well-succeeded integrity program. We have in our portals clearly informed our sustainable development guidelines. We incorporated the SDGs in our credit analysis. We want to map here in BNDES, not only aligned with the transition to a low carbon economy and global climate agenda, but also aligned to the sustainable development goals. We'll have a real-time mapping for all operations, considering these elements already developed, being done, so incorporation of the SDGs and incorporation of this new agenda within our program. And I leave here a reference and data management within BNDES. I had to say in this short space of time, thank you very much. I hope you all enjoy lunch.
Thank you so much, Dr. Walter Baer Filho, for your brilliant words in this compliance seminar that we're having here. And I'm going to pass the floor to Teles for the Márcia Reis, please. The floor is yours. So in the name of, on behalf of IIEDE, we would like to thank this great discussion that we have with the great players of the international scenario and for the sharing of information and the deep learning that we've had. Getting what everyone has said here, I'm sorry, we are perplexed with all of the information that you have brought here about what we need to take into account in terms of compliance, but considering Dr. Marcos in Banco do Brasil, he is the main fosterer of public policies in rural credit that we had the pleasure to work with Patricia with her trajectory of compliance since the beginning. We had the 4.0 compliance and Pinelli with your easy speech with the compliance that approaches support with like no other. Marcelo Pontes with your perfect technique regarding CGU and the collaborative practice. He said, we can also have questions regarding that. And our associate for the brilliantism of the engineers and Dr. Walter with his questions regarding what has been put as environmental risk and so on. So what does this algorithms bring to us? And thanking our chair here, not only from IIEDE, but from the table as well, who has brought this brilliant view with all of the theory related to compliance. Also talking about the sanctioning and how is the application today in the Brazilian law and our society. Thank you so much. With the beautiful closing words of Vanessa Reis, I would like to thank everyone, especially to the people who were indismissible for the seminar. Our advisor, Lucas Alvarez, Pedro Leite, an associate of Medina Osório Law Firm. I wish you all a great lunch, inviting those who were lecturers and brilliant speakers here today. So thank you all so much.